So is there anything you'd like to ask me about the substitute decision-making? Yes? So I don't know if everybody heard the question, but the bottom line is that there's 3 attorneys named for property, and they all have different motives and intentions of what to do with the money. A couple of them involving just personal interests and not the interests of the grantor. That's a really difficult situation, especially if there's no decision-making mechanism in there. In this case, are they allowed to decide individually as well as together? Oh, okay. So, I mean, if they were allowed to decide individually, that might be even more of a problem, because one could just go off and do what they want. If you have a situation like that, and you, well, sometimes you can get a mediator. Sometimes it's worth investigating in a mediator to sit down, especially with the grantor present, depending on the capacity level, there might be a way of impressing upon the attorneys that their job is to act in the best interests of the grantor. I mean, you could also, if you're the one who is actually doing the job properly, you could point to what the law says. But ultimately, the only way of, if it's just an impasse and it looks like somebody's going to make off with the money, you may have to go to court. You may have to get someone, take action to remove an attorney or both, and present the evidence before a judge. It's definitely one of the duties of an attorney for property to keep accounts. I don't know if enough people know that, but and to keep the money separate, like not put the grantor's money in with your account. Yeah, because it's almost like, you can imagine it almost like being a business manager for someone, and it should be very scrupulous. And it protects you, as you say. You know, you can't be challenged then if you've acted in good faith. And I mean, you don't have to be, you may make mistakes, but if they're honest mistakes, it'll probably be a fine. You know, you can't always, if, you know, it could be that the loved one's investments go down in value. You may not have sold them in time, but you know, that, as long as you're keeping good track what you're doing and you're acting for them. Yeah. Anybody else? Yeah?
Okay, I'm trying to understand the difference between capability assessment, which the Attorney General has a list of people who can do that, and which I am reading the thing, I get the impression is basically to show you're not capable of doing something. Yeah. Whereas my lawyer is asking for a testamentary capacity to prove that my husband is still able to sign his will. Is there really a difference between those?
Well, there is a bit of a difference, because if a lawyer who meets with a client to make a will is first, I mean, capacity is presumed to exist, right? But it's a legal determination whether a person has testamentary capacity or the capacity to make a will. So the lawyer would want to speak to your husband alone, not with anybody else present, to ask some questions to see if
She's asked me to go and get, to provide her with an assessment.
Oh, I see. Well, then I think the assessment you're talking about is through the Capacity Assessment Office, which is it's kind of an arm of the Ministry of the Attorney General, but they have this roster of assessors, and it's, you know, it costs a certain amount of money to get them, and there is a financial aid program, but yeah, I mean, yeah. So it sounds like
I'm just trying to find out the two things.
It's interesting. The lawyer generally can make the assessment themselves, but if the lawyer is in doubt, they may want to see a medical assessment. But it's interesting. I think lawyers. I was at an event once a conference once where the lawyers and the doctors were talking among themselves about this whole issue, and frankly, there was a lot of misunderstanding between the two of them about what legal capacity is versus medical capacity. And I don't think it's ever been, I think it really depends on the person's state of knowledge about that issue. So, I mean, normally a lawyer can make the assessment, and as to the ability to make a will, that's what I would say. Yeah, that's a little bit different. If you have a joint account, and sometimes it's not just husband and wife, but sometimes parents put their children on, and if your accounts were mixed to begin with, and you pooled it, then that's different. But you might want to keep receipts and so on, items that you have to buy specifically for him. The other thing is you don't in that case you don't need to show the bank a power of attorney, obviously, but you would need it for the tax people. And it's also a matter of sometimes nobody challenges you. I mean, is there anybody in your family who's going to challenge you? Yeah. So it's more important to be. I mean, in your case, that's not an issue if your accounts are joined already. But sometimes I deal with patients who might have one child, and they're also going to be the beneficiary in the will. So there's nobody around really to challenge what they do, which is good and bad, depending on their level of honesty. So that's fine. Yeah. Yeah.
Just add something then, which perhaps is important to other people. The whole point the lawyer is making about there might be a challenge is because we have left some portion of our income to charities. And I'm given to understand that charities have now started challenging bills. I can't believe this, but that, if you've left 1/5 of something to this charity, that they will come back. My family's not going to challenge anything. This is all to do with charities maybe challenging. So I just wish I never put charities in my first will, because that's causing all the problems. But I find it quite incredible that would be the case.
So charities are saying we need more.
In general around the city, the big charities are actually challenging people's wills on occasions that they're not getting the proportion that they thought they wanted.
Yeah. Or they're making sure that if they are given anything in the will, that it gets. So they would only know if the will were probated in public, I guess, or whether if the person had been in touch. Yeah, that's a very interesting point. Has anybody run into any problems with their using the power of attorney at the bank? Yeah. What did you? How did you resolve it? Because we've had a few patients at the hospital who've run into issues too.
It was a bit of a technicality, and I don't think I've resolved it. We've just sort of left it as is because I challenged the bank representative to speak to counsel and have counsel make a different decision on it, and they never reverted. What it was very technical. Is I had just a very basic power of attorney from the District Attorney General website.
Mm-hmm.
I didn't get a lawyer to draft one up, so it wasn't notarized. And so I had it witnessed and so forth, and the representative said to me, well, we don't recognize this. It's our policy that you have to have, and I believe it's the certificate of attesting to the fact that the witnesses were present and signed, that sort of thing, like you would for a will.
Mm-hmm.
And they wanted it notarized, and they were very uncomfortable. So they're not recognizing what is effectively an enforceable power of attorney under Ontario law. So I'm not even sure how to deal with them on it, because it was almost like they're just refusing it. It's their policy. So I don't know if there's something you can do in those situations, or you can say to them to enlighten them. But I think they're referring to in-house counsel, so that's their position, and they don't change it.
Yes. Well, with powers of attorney, you don't need. You're not supposed to need the affidavit of execution. We provide that here in the hospital to try to make it easier, and we do the notarization. And you can download an affidavit probably from the internet, and all it is one witness swears that they were present and watched this grantor give the powers of attorney on a certain date, and then it's commissioned by a lawyer. You take it to a lawyer, and the two witnesses would have to be there and all that. I mean, it's a kind of a rigmarole, but it's not legally required. But unfortunately, or maybe fortunately, in terms of fraud prevention, the banks all have their policies, and they don't necessarily put them on their websites. Each bank could be different. One of my colleagues here told me that one bank said, well, this only authorizes you to make deposits, not withdrawals. And, a power of attorney gives you broad powers generally, unless it's said otherwise. So you may have to sort of try to arrange for that affidavit, I guess. And notarization isn't a big deal. Usually it's about $25 for the first document. So you can get as long as the witnesses are available still. Sometimes that's not the case.
But if you've already had challenges with someone who has mobility issues and you can't get them to a lawyer, can't have a lawyer do a house visit sort of thing.
That's right.
That's very challenging.
Yes, exactly.
But if I could just make a brief comment
Sure.
on what the lady said, just based on my experience, I went to see a lawyer about inquiring about the will and so forth, and he's a very experienced practitioner, and he too said, I think I'd prefer to have a letter from the doctor, from the GP saying that this individual is okay. So I totally understand that, and I think you're probably right. It's just to have that extra documented support by the lawyer that they cover their bases and that. So I think it's understandable, even if
Yes.
it's not technically correct.
But the doctors that we were with at that event said, I don't want to sign these. I don't want somebody to say, oh, I want you to testify that my mother is capable. Well, they may not know the mother that well. They may not do that much in that kind of work, and they're being asked for that a lot because lawyers are more and more nervous about having these documents challenged. So that's something that needs to be worked out. But it's quite it's a pretty complex area for something that's so fundamental to how we can operate it, as we get older and we have older parents. So, anybody else with a comment about, or any questions about wills or anything? Wendy.
So just a comment as opposed to a question. You'd mentioned that people can put down that the physician can make them incapable. From a practical perspective, that becomes very hard in a hospital when somebody's been admitted. They've changed significantly, potentially, since they last saw their family doctor, but it's written in the power of attorney that the family doctor is going to make the decision. It can become quite complicated to try and act that. So when putting in conditions to think about how feasible it is if somebody suddenly becomes incapable and ill, how the medical team and yourself are going to make sure that the power of attorney comes into effect appropriately.
What would be the sometimes we say attending physician, so it could be the physician who's there now. That makes it a bit easier, I guess.
For treatment decisions, as you said, it's less onerous.
Yep.
Each individual decision is a practitioner, but if it's put in the power of attorney for property, like you say, some physicians aren't comfortable doing that.
Right.
So it kind of leaves you in limbo.
Right. And the ideal would be, say, a designated assessor, but that costs money, so people don't always want to say that. Okay. Are you ready? Thank you very much.
Nancy, thank you very much. That was very informative, and given by the responses and the questions of the audience, I think it was very successful. Thank you so much.